everyone, today I'll be discussing about the sources of Hindu law. First, I'll go for the introduction, then the sources of Hindu law, then the conclusion. First, let us understand the concept of law under Hindu law. So, Rig Veda stated that law was a course of conduct to maintain the cosmic order. Everything was considered to be a part of cosmic reality. In the Sam Veda, like the natural school of law, it believed that law was of a divine origin. The positivists nevertheless considered law to be man-made, and the non-positivists believed that law was of a divine origin. Hindu laws originators fall under the category of non-positivists. Under the Vedic period, law was considered to be a device through which security was assured to the citizens and subjects. Law is always supreme and above the king himself. The Hindu law criticized the unlimited power given to the king, and there was no role for tyranny under the Hindu law. Everything functioned in their respective spheres. There was danda imposed if the respective spheres were not followed, according to Manusmriti. There was fear which made people follow law, and there is always a theory of force which stated that fear was a key which beholded law in the system and the society. The Austinian law stated that law emanated from the sovereign. So it stated that sovereign was given an upper hand over law itself. But under the Hindu law, law was always supreme and the king was below it. And sadachara, that is the customs or the usages, were given an upper hand compared to other sources of Hindu law. We'll be dealing with the sources of Hindu law in the next slide. And the concept of rule of law is also a part of the Hindu law, like equality before the law, and law was always supreme and above the sovereign himself. Let us now understand the primary sources of Hindu law and the secondary sources of Hindu law. So the primary sources of Hindu law are Shrutis, Smritis, commentaries, customs. Secondary sources of Hindu law are judicial decisions, legislations, justice, equity, and good conscience. Shruti meant to hear. It was the law which was passed on to the rishis by the god himself. So the Shrutis contained ways through which salvation could be attained. We have the four Vedas that have been dealt under the Shrutis. The four Vedas are Rig Veda, Yajur Veda, Sama Veda, Atharva Veda. And Vedangas like the Kalpa, Chanda, Shiksha. Smritis are what is remembered. There is a need to distinguish between Dharma Sutras and Dharma Shastras. Dharma Sutras are always written in prose style, and Dharma Shastras are written in shloka form. So the various Dharma Shastras are of Manu, Yagnavaikalya, Narada, etc. So Yagnavaikalya's Smriti was more liberal compared to Manusmriti, and Narada Smriti gave right of separation and remarriage to women. Katyayana Smriti gave the concept of Sridhana and women's right to property. And Arthashastra dealt with Dharmastiya and Kantakhashodhanam, meaning civil law and criminal law. And in case of conflict between Shrutis and Smritis, Shrutis prevailed. For an illustration, the concept of sati did not have any mention or sanction under the Shrutis, but it was part of Dharma Shastras. So here, in case of conflict between Shrutis and Smritis, Shruti prevailed and the concept of sati ceased to exist and it was abolished. There were conflicts in the Dharma Shastras. Commentaries came to rescue. Few of the commentaries are Mitakshara by Vignaneshwara, Vyavahara Mayuka by Nilakanta, and Dayabaga by Chimutvahana. Under the Mitakshara, the rule of inheritance was the rule of survivorship. Under the Dayabaga, the right to property arose as soon as the death of the last heir of the property. There are a lot of distinction between Mitakshara and Dayabaga that will be dealt separately in a different video. Let us understand custom. So what is a custom? A custom is a practice that has been followed in perpetuity, continuity, antiquity, and is not opposed to public policy and express provisions of law. There is a custom in South India where the vest of a person has to be removed before entering the temples. This custom has been followed in antiquity, that is, it is an age-old practice, and in perpetuity, that is, since time immemorial, and in continuity. There has not been discontinuousness in the practice, and it has been clear, and it is not opposed to public policy, and is not expressly prohibited by law. Now, let us understand judicial decisions, which is one of the secondary sources of Hindu law. So, the rules of adoption changed as soon as certain judicial decisions came into existence, and there were changes in the rules of adoption, and there was delimitation of pious obligation. So, a son was considered a means through which the ancestors attained salvation. So, pious obligation stated that the grandson is a way through which the grandfather attains salvation. And pious obligation also stated that the son had all the rights to repay his father and grandfather's debt. The judicial decisions also stated that a co-parsoner had a right to alienate the property, that to his share, in certain circumstances and in certain provinces. And there were limitations with respect to Sridhana, which was imposed through judicial decisions. There are numerous legislations when it comes to Hindu law. Here are some of the legislations. First one is the Child Marriage Restraint Act, which increased the age of marriage for women from 16 to 18 and from men from 18 to 21. And Hindu Women's Rights to Property Act, which gave women right to property. Prior to 2005, women did not have equal rights to property. But after 2005 amendment to Hindu Succession Act, women became equal co-partners. And Hindu Widow Remarriage Act is gave widows right to marry again. And Sati Abolish Act and Hindu Marriage Act and Hindu Adoption and Maintenance Act. There were conflicts in the Dharma Shastras, judicial decisions, legislations, and when the question of law was not answered, justice, equity, and good conscience came into rescue. So, Brihaspati stated that along with the rule of divine origin, the rule of reason should also be followed while practicing any custom or any law as such. And Narada Smriti stated that in conflicts between Dharma Shastras, conscience has to be taken into consideration. So we can say that good conscience, equity, justice were a part of Hindu law but were not dealt separately. This was more of an English origin, but it was nevertheless there as a concept under the Hindu law. I would like to conclude by stating that law is always of a supreme importance as compared to the king. Prajasuke Sukham Rajna Prajanam cha Hita Hitam, which meant that the welfare of the subject is the welfare of the king himself. Law was of a divine origin according to the Hindu law, and it was in contrast to the positivists who believed that law was man made. So, Hindu law has been divided into two classes, primary sources and secondary sources. Narada placed customs above Dharma Shastras. That's all with respect to the sources of Hindu law. Do let me know in the comments what are the next topics I'll have to cover.